Ms. Mitchell?
Good afternoon. On behalf of Animal Justice, I would like to draw the court's attention today to the experience of claimants in challenges to government laws and actions that impact the rights and interests of animals. And as Justice Sawson recently observed in Schnur and Canadian Tire, claimants in such cases have faced particularly difficult challenges in meeting the threshold for public interest standing. To illustrate the challenges faced by such claimants, I invite the court to review the cases set out at footnote 8 of Animal Justice's Factum. And I will not take you through those cases today, but what I would say is that they demonstrate that claimants in cases involving animals face challenges satisfying all three branches of the Downtown Eastside framework. Before and after Downtown Eastside, the seriousness and justiciability analysis has proven particularly challenging. But under the third branch of the analysis, courts have repeatedly also identified, quote, more appropriate approaches that claimants could take. That includes filing complaints with law enforcement or private prosecution. So we've set out more detailed arguments in our factum, but at a very high level, what I would say is that the experience of individuals and groups in cases involving the rights and interests of animals illustrates two overarching points. The first is that it is not in the interest of justice to place even greater restrictions on the granting of public interest standing, as the appellant and several other attorney generals have requested in this appeal. And this includes in particular any requirement that where a proposed public interest litigant lacks a directly impacted co-claimant, that they should be required to, quote, compensate by adducing particularized evidence regarding how they will prove their claim on the merits, even when standing is challenged at an early stage. In challenges to laws or government actions that impact the rights and interests of animals, there will not generally be evidence from a directly impacted co-claimant or even directly impacted witnesses. And would-be public interest litigants in these cases should not face a greater procedural hurdle than claimants in other types of challenges. And in fact, courts' approach to standing should be focused on the need to facilitate access to justice for vulnerable groups, such as animals. Similarly, the proposed incorporation of the language of proxy, as suggested by the Attorney General of BC, is not a workable standard in cases involving the rights and interests of animals or aspects of nature, and that argument is set out in more detail in our factum. The second overarching point highlighted by cases involving animals is that in order to safeguard the rule of law and ensure that governments do not abdicate their duties to protect vulnerable groups in society, the Downtown Eastside analysis should be conducted in a manner reflective of the nature of the case and the nature of the rights and interests at stake. And in cases involving vulnerable groups, particular emphasis must be placed on the objectives of promoting legality and facilitating access to justice. In such cases, courts play a particularly important role as guardians of the rule of law. They must ensure there is a practical and effective means to challenge laws and government actions through the granting of public interest standing, even when those whose interests are at stake are vulnerable or even voiceless, in the sense that they cannot express their interests through judicial or legislative processes, even when those whose interests at stake are not persons. With respect to the cases listed at footnote 8 of our factum, I would like to place particular emphasis on Rees and Zuchek, two Alberta Court of Appeal standing decisions arising out of claims regarding the conditions in which Lucy the elephant is kept at the Edmonton Zoo. These decisions contain extensive and impassioned dissenting judgments emphasizing the need to promote legality in the context of laws and government decisions impacting animals by taking a generous approach to public interest standing. In their dissenting judgments, both Chief Justice Fraser and Justice O'Farrell emphasized the importance of promoting access to justice in cases involving animals and other cases where novel and important points of law are in dispute. So in summary, to ensure public interest standing performs its important function in the Canadian legal landscape, emphasis should be placed on legality and access to justice in cases involving vulnerable groups, and unnecessary barriers should not be erected to prevent access to the courts where appropriately placed public interest litigants bring forward justiciable claims, even when those claims are novel and contest the existing boundaries of the law's application.
Thank you.
Thank you.